Welcome to the Yeoman podcast. I'm your host, Jeff Graham. On Yeoman, I will speak with people who build and grow things, people who create art, and people who think about community, meaning, and purpose. One of those people is Charles Gardner. Charlie is a research fellow at the Mercatus Center whose research focuses on planning law and housing affordability. He is the author of the Old Urbanist blog and has worked on zoning and land use issues as a local elected official. He's also been an active participant in state policymaking, where he served on the Connecticut State Advisory Committee to the U.S. Commission on Civil Rights and the Commission on Connecticut's Development and Future. If I were forced to label Charles Gardner, I would call him a philosopher lawyer, and I look forward to speaking with him about the law, property law in particular, its history here in the United States, and how it shapes our communities. Charlie, thank you for joining me on the Yeoman podcast.
Well, thank you very much, Jeff. And I'm very happy to be here talking with you today about a bunch of subjects which I think are of mutual interest. But
Absolutely. So where are you right now? Where are we?
I am sitting in my home in Newtown, Connecticut.
All right.
So
I've heard of Connecticut.
Yeah. Back in New England, I was down in the Arlington office earlier this week.
That's where the Mercatus HQ is. Is that right?
Yes, they are in Arlington, Virginia, just over the Potomac from DC. So
the only I'm pretty sure I've only been to Connecticut once in my life, and I was probably a young teenager at the time, so I don't have any vivid memories about it. But what's Connecticut like?
Well, it's
clearly the people are great.
The people are fantastic. Yeah, it goes without saying. It was for most of its history. I guess the history post English settlement, was an agricultural state. It's a farming state. Cities were small. Population overall was not that big. Then industrialized heavily in the late 1800s. And then the third stage of development has been exurban, suburbanization over what were previously farms. So it's an interesting mix of sort of older cities, some newer investment, and widely scattered suburbs, and a few remaining agricultural activities, but not many compared to the history of the state. So,
where are you from originally?
I was born in Westchester County, but all my family's from Connecticut.
Gotcha.
So that was just a detour, and then they came back to where the family had been for. I've been in the state for a long time. So
gotcha. Well, I'm recording here from my home in Midtown Atlanta.
Yes. Okay, excellent.
Yeah, and it's a threateningly rainy day today. But we need it. Spring has arrived here in Atlanta, and the pollen is everywhere.
Oh, okay. Well, I hope you have some Allegra or Claritin or something. I'm just on the verge of using that. I think the rain is going to come. That rain is going to hit us tomorrow.
Yeah, good. Well, we need it here. I just tend to power through on the pollen, but it's spring is Atlanta's marketing weather, so it's totally beautiful here. But I'm happy when the rain comes.
That part of town is interesting. I've only been to Atlanta once before, but that was a rapidly growing and developing part of the city.
Yeah. I'm from Atlanta originally, and though my dad, whom you've met, is from a small town in South Carolina, my late mother's from the North Georgia mountains, a little town there, township maybe you might call it. And they were the first to kind of come to the big city, I guess, and started planting roots there and stayed there. So I've been here with some professional journeys to the South Carolina Lowcountry. Other than that, I've been here most of my life. But and I have to say, as much of a bad rap as the city of Atlanta gets for traffic, if you choose to live in Midtown Atlanta, you don't really deal with traffic. You just kind of, it's not a problem we have here.
Yeah. No, it's everything you need is close by, and you are on the main line there of MARTA. So
it's a pretty easy walk. I mean, we drive a bunch, but it's a pretty easy walk for just about everything. On land use, I'm interested in speaking with you about I know both of our favorite topics, zoning, really everybody's favorite topic. And I guess my first question about it is, we're approaching the centennial of Euclid v. Ambler. So have you thought about how you're going to celebrate in 2026?
I haven't picked a site for the celebration yet. Getting ready on that. I think it's going to be a real big blowout gala. So we'll see. A lot of celebration around that decision. No, but yes, it is coming up, right? Only a couple of years away, and the case itself was argued even well before that. It took the court a while, and they had to re-argue the case and ask for supplemental briefing and all that before. Oh, really? I didn't know that. Getting a decision. Yeah, I mean, that's what I've heard, that originally maybe the case was going to go the other way, and then there was some supplemental briefing. And let me briefly interject. So, I mean, we're kind of joking about loving zoning, but we do talk about it a lot. The case we're referring to is Euclid versus Ambler. I went into that in great deal with, I think, our second or third guest on the Yeoman podcast, Ilya Somin. But maybe, Charlie, if you could give people a really high-level description of what that Euclid v. Ambler case did and why it matters in America. Yeah, like the 30-second version is, it was the first Supreme Court case to assess whether cities could lawfully divide themselves up into zones based upon use of the property as well as the physical form, which was really the question before the case. Could they, question before the court in the case, could they exclude residential use from an industrial area, even if residential use was not a nuisance, was not a noxious use? And the court basically said that even though this involved rights to use property, the standard of review was going to be very forgiving. That is, the city had a very low bar to show its interest in regulating in this way, and let the city through. This is the city of Euclid in Ohio, near Cleveland. Just let it by with flying colors under this rational basis test, that any justification the city had for this overall planning scheme passed muster. So with that, the Supreme Court basically dealt with the major issues at play in zoning and has never really revisited those issues, at least not in a comprehensive way, since 1926. And zoning is fairly common. Would I be right to say that it was the Euclid decision that, this is probably reductionist, but that transferred the total authority over what might be built on one's property from the property owner, and transferred a great deal of that authority to the municipality? I think that's fair, or at least confirm that there were no federal constitutional protections for the individual owner in that case. Right. And that the municipality, basically for any reason that it saw fit, and there's only a few reasons which have been found to be in excess of the municipal power, could restrict use however it wanted, pointing to health, safety, public welfare, almost anything. Do you recall what how the voting went on that decision? I think it was a 6-3 decision. Unfortunately, the minority did not pen a dissent in the case, so we lack a Euclid dissent. However, there are a lot of state court cases, state Supreme Court cases, which ruled on zoning, some of which remain in effect, which did come out the other way. I was just talking at Yimbitown with an attorney down there, for example. It's a case called Spann versus the city of Dallas from 1921, the Supreme Court of Texas, which struck down residential only zoning. And that case, although seemingly overruled by Euclid, still remains good law insofar as was decided under the Texas Constitution. It's a city about residential zoning in Dallas. That's still on the books, and if you're interested in it, it's a good read. And we'll
link to that in the show notes.
Yeah. Spann versus City of Dallas, never reversed. It's still on the books.
What is that first? Did you say Spann?
Spann, Spann. Yeah, Supreme Court of Texas, 1921.
I, being curious about the court's makeup at the time and that Euclid decision, which to me kind of seemed sort of crazy. Like I would be astonished if today's court or even recent courts would come out and say, hey, zoning is fine, especially given all the kind of the background and discussion around it. And I'm simplifying that, but I am interested in I've found it interesting, the who voted yay and who voted nay on that decision. That same Supreme Court also is responsible for maybe a more widely known controversial decision, the Buck versus Bell decision.
Yes.
Are you familiar with that? Which is still on the books, which says that the state may sterilize people it deems unfit to have babies, and which was widely used to sterilize people who were deemed having insufficient IQ, and that I believe the dissenters I think there's only one dissenter. It might have been two dissenters on that. That was also one of the Euclid dissenters.
Yeah, it was an interesting era for the court. I mean, they were, or at least today, they're accused of being activists, or at least some years earlier with the Lochner case, and actually interfering with municipalities' ability to legislate public health and safety. And then in Euclid, I don't recall how many of the same justices were still on the court, but they seemingly took a different tack here, even though it was, I believe, considered to be a fairly conservative court at that time, and one which, at least, some of the justices were protective of, saw themselves as being protectors of property rights. So the history of how it worked out exactly the way it did, there's a paper or a book that's really delving into that, because the procedural way that case went through with supplemental briefing and re-argument, I think was a bit unusual.
I recall a podcast which I found interesting. It was about Oliver Wendell Holmes. It was on the Art of Manliness, of all places. I think Brad McKay. I think he has a great podcast there. But he went into sort of the psychology of Oliver Wendell Holmes and two other really prominent people. The three of them were really good buddies, and how the Civil War and then World War I, the devastation that people going through that had witnessed, had made them kind of relativists, and in a way that the whole notion of sort of constitutional originalism would have been, absurd to them. And they had seen so much pain and destruction and brutality over the time that it had jaded them in a way that they were pretty much like, if it be the will of the people, if people tend to feel this certain way, then that's how our laws should reflect how people tend to feel in the time, the zeitgeist of the day. Does that make sense to you? Do you know anything about that?
It does. And actually, I think you can see the same attitude brought up. I know it was later on your list in the Wilson versus Shaw case. Mm-hmm.
Yeah.
Where they say,
which was 1907.
1907, yeah. But there's a similar statement in Euclid as to the effect that, it is, things have changed now. It's too late now to revisit some of these questions, even if there might be some point under an originalist interpretation. the circumstances have changed. Now we have railroads and all these things that we didn't have before. So really the picture is very different. And that's echoed in Euclid by saying, if it might not have been constitutional back, before the rise of modern cities, but now we have to deal with all of these other various newfangled concerns with pollution and automobiles. And that means that the Constitution will have to essentially adjust, or the scope of the constitutional protections will have to adjust, which, they try to claim, well, that doesn't mean a substantive difference. It just means a difference in the application of the principles. But it can be tough to tease that apart, to say, that technology means that the scope of the constitutional protections has to yield, which is effectively what Justice Sutherland also says in the Euclid decision. Hey guys, times have changed, just like the majority wrote in 1907 with respect to the technology. So a similar, progressive mindset reflected in both those opinions. Times are changing. It's a new industrial era, and these quaint notions of limitations on the federal government or protections of individual property rights have to yield to these new realities, at least to some extent.
And the Wilson versus Shaw 1907 case that I do really want to talk to you about, because I feel like it's under discussed, kind of really was centered around, it was brought about by Teddy Roosevelt's desire to begin investing in the Panama Canal. But it had implications for domestic internal improvements, they were called, which historically had been the framers of the Constitution had been, I think, reasonably explicit that the federal government should not get into the business of making internal improvements. And internal improvement today would be something like the interstate highway system. And the Wilson versus Shaw case turned that the other way. I do want to talk about that a lot, but I don't want to leave the topic of zoning yet. And I would really love to get your take on, because I'm sure you've read it, on Ilya Somin and Josh Braver's recently published article. And I think the title, I should remember it offhand, but is "The Constitutional Case Against Zoning." Do you have any a take on that to share?
Yeah. Oh, it's I think it's an excellent read. I really enjoyed it. Just read it actually a second time before this because I wanted to refresh. I read it, I think, as soon as it came out, and then wanted to sit down and go through it a little more slowly to see if I could absorb some of those points. Yeah, constitutional case against exclusionary zoning, but which they really mean that the takings case against zoning. Really, the argument is for reinvigorating the takings clause to go beyond where the Supreme Court has left it now, which is essentially takings is equivalent to possession. And the only way a taking can be found is if you actually take title to the property, right? Or if you completely destroy all value. But that's really hard to show. I mean, how do you completely destroy all value? You could leave somebody any minor right they have to use the property for some purpose. It's just
there's some. You may know the details of this. There's some case regarding a property that due to some sort of infrastructure project, nearby a highway project or something, someone's property was regularly flooded all the time. So it was not that it could still be used, but could not be used to the extent that it had been before the flooding. And I think that was. Do you know what I'm talking about? Yeah,
they do cite that case. I don't remember off the top of my head, but I think that still falls under the sort of the physical invasion side of the test, where it's a taking. If there's a physical invasion of part of the property, and that would include destroying it by flooding. But the court has resisted what they're suggesting in this, what Ilya Somin and Josh Braver are suggesting in this article, that use be included as part of those bundle of rights which can be taken away and thereby subject to compensation. It's essentially what they're arguing, a broader view of what property rights actually mean in the context of the Fifth and 14th Amendment, which they actually do cite the lower court case in Euclid, where the judge in that case exactly embraced it. He recognized, well, you can't disentangle the value of the property from its use. A property that has no lawful use is going to have no value, and the value can increase as the scope of uses broadens as well. And that's also something that was echoed in the Spann case, which I mentioned. So there were courts that were viewing it this way in the 1920s, contrary to the Euclid case. So there is some precedent, I think, for taking this viewpoint that they advocate here, and setting aside Euclid, saying, well, we're not going to view Euclid as a takings case. We're just going to view that as a police power rational basis case. And what they're suggesting, which, I think is a plausible argument, is to say, no, the takings doctrine should be expanded here, using as a springboard the modest expansion of that doctrine over the last 30 years, with regulatory takings, seeing exactions as potential takings, other things which are only of a monetary nature. So it could certainly, I could see it being a strategy. The other way you can do it, rather than fighting this as a federal issue, they don't get into it as much, but it has been done successfully, I would say, is making it a matter of either state constitutional law or state law.
From a legal path or a legislative path?
A legislative path.
Yeah.
Such as Arizona and Oregon have done, essentially redefining the law, writing into the law, saying that a taking can encompass diminution in value of a property, which was passed by ballot initiative in Arizona some years ago. I think one was just before the Kelo case and one was just after.
And that's a different strategy than what we've seen in California and Montana, it'd be a very different strategy. And I think Oregon's caused some controversy because they didn't even limit it to new zoning laws that you could say. They said you could apply it retroactively to any law that existed even previously. So if a municipality tried to enforce their zoning, a property owner could deem that a taking.
Could deem that a taking, whatever the diminution in value is.
Interesting.
Single family home versus a quadplex, taking 50% of the value or 75% of the value. So you can get to the same result that they're advocating here. When
did that happen in Arizona and Oregon?
The Arizona law was passed in 2006, and Oregon was 2004. But then it was modified and narrowed in 2007, in each case by ballot initiatives. So these were popular measures.
What is that's a long time ago, a couple decades. What's the impact of that then?
I think in Arizona, at least, because it's not retroactive, it makes it very hard to downzone, to take away. Anytime you want to reduce the current use of a property, that's going to be seen as a taking. Compensation is going to be owed.
Right.
Oregon's approach is even more aggressive, right? So you could challenge existing zoning. Yeah. And they apparently saw a flood of development applications, urban and suburban.
And in the case of Arizona, generally though, sort of downzoning property, a municipality downzoning property it's not all that common anymore. Like most places that are going to have zoning already have it. And it's real hard for municipality to downzone.
Yeah,
it happens.
It's a floor, but you're right. It doesn't really allow an attack against anything that already exists. Although,
so it sounds like Oregon is more significant.
Yeah, although they walked that back a few years later, I think because it was too effective in overriding zoning in 2007. Didn't make it eliminate the retroactivity completely, but made it much harder to challenge existing laws because they were seeing a flood of development applications in a way that was perceived as being against the state's long-term goals for growth. Not that couldn't have been managed, but they tried to reach a compromise. But it seems like it was very effective because you could challenge 100-year-old zoning laws as a taking.
So that would seem like an effective strategy. Montana didn't pursue that path. California didn't pursue that path. I don't know. That's new. That's a new thing to me. Why aren't other states doing that? Because clearly there's appetite among legislatures and governors to liberalize zoning restrictions.
Some other states wrote a similar provision into their constitutions after the Kelo case in 2005. In some cases, those have been more symbolic than others. I think the Arizona and Oregon examples of actually legislating it in some detail have been more effective. But other states did pass something similar. Of course, the concern there was more taking, right, in that case, taking for what's perceived as being a private use rather than taking without compensation. But it did inspire some renewed thinking as to what a stronger takings clause might be at the state level.
This is, the podcast is entitled The Yeoman, and it is about kind of the creative force of individuals and their communities and autonomy and building things for yourself and those that you know and care about who are close to you and having the freedom to do it. And then also the forces that may abridge those freedoms and get in people's way of pursuing their own path. Which is, if any of my 17 listeners, if you're wondering, like, why is Jeff always going on about zoning? And this notion that you may not do with your property what you want to do with it. I think it has observably has had enormous impact on our communities and the connectedness of humans and their ability to sort of chart their own course with the world. And I would say I'm actually, though we're now, roughly 100 years into some form of this and some kind of attack. And this is probably a good time to go into the Wilson Shaw part. But though it's been 100 years where, we've had communities being attacked a bit on by the courts and by lawmakers, I am feeling incredibly optimistic right now. Like, as much enthusiasm around these topics and as much awareness from everybody, from people of really diverse political persuasions, and both Ilya Somin and Josh Braver are kind of two different sides of the aisle on this topic, and they've come together on this issue. But governors as different as the governor of Montana and the governor of California seeing eye to eye on this issue. And then just kind of lay people starting to recognize, like, hey, maybe all this stuff is terrible and we need to let people do cool things again. Which from where you sit, you're influencing policy. Well, I guess we have you to thank. Thank you for that. So you influence policymakers. So what's your level of optimism on this?
I would agree with you. I think there's, over the last 100 years, probably never been a more optimistic time in terms of what we see going on at the state level and what you see going on in discussions. I mean, a lot of these points, you can look back and yes, they've been made before, and certainly people were aware of the exclusionary effects of the American way of zoning going back to the 1920s, including the district court judge in Euclid, who saw right through the whole thing, that this was not about health and safety, this
Yeah,
was
that's a great opinion to read that opinion.
Yeah, right. It's like he knew exactly what was going on, that this wasn't a proper use of the police power. So it hasn't been a secret, and it hasn't been some sudden epiphany, that the YIMBY movement has had, that nobody's had these thoughts before. But I think they've been more widely disseminated. And also, unfortunately, the negative effects have become more and more apparent as time passes, as these, cities change, the country changes, trends change, economies change, but the zoning doesn't change. And for a while, you might get away with that. But then as time moves on, the economic reality and what people would like to do diverges more and more from what the zoning map allows you to do.
It seems to me, too, the problems compound. Like over time, we as a people, we design our systems and processes and infrastructure and investments. We invest them more and more and more to reflect the zoning or the transportation policy or whatever those things are, and they compound. And so I guess while I am feeling really, really optimistic, maybe the reason for the optimism is because it has gotten so bad and difficult and clearly unsustainable to more people.
I think that's definitely part of it. It can't be ignored anymore by people or by those representing them, which I think is why you've seen so much activity in state legislatures, starting in California, where the problems were already acute going back years, but now spreading to many other states. And I'm sure there has never been more activity than there was just in the last couple of years at the state level, in terms of finally taking back the zoning power and setting some real guardrails on it in terms of what localities are able to do. It's the first major change, with a few exceptions here and there due to court interventions. The first major change since the states, as I say, basically gave the car keys away to localities with the zoning enabling acts and says, here you guys go, whatever you want to do, it's yours. We're not gonna bother limiting it in any way. We're just going to set some rules for you and how the procedure is going to work, but the substance, have at it, whatever you'd like to do.
Right.
Which obviously didn't.
I'm a big fan of localism in general as sort of the default subsidiarity, and people are like, oh well, you should like this, like local authority over what happens. And I have to remind people, like, the localist authority is the owner of the property. And at a federal level, we undermined, or we removed I don't know how I would probably frame and say it as, I don't know if it's right, but we undermined the most local authority, and gave it to a middleman.
Right. Exactly. Yep. No, I share your Jeff. I share your enthusiasm about what's going on now, and despite the occasional setback here and there in court or governor's veto or whatever it may be, the agenda rolls on, and there's more and more of a consensus that's being built around these ideas in a way that there hasn't been before.
And I'm excited that there's several paths. I mean, you described that there's several paths toward liberalizing land use restrictions, and I use that word as like giving more freedom to what people can do. And people are talking about them all the time, or at least in my circles, which I will say I've been in the building business now for, I guess over 30 years, if you count my teenage years. And people were not talking about this 30 years ago or 20 years ago. And people, the most sort of clear-eyed few of the very clear-eyed people, and the most clear-eyed people within the profession of building, even the person that was like, hey, zoning is a problem 15 years ago, that was not a common opinion. And now it's very common.
Right. I think the speed with which it's happened is, even sitting here, we can miss that, right? That the transformation in the popularity of these views, how many people are aware of them, compared to, 10, 15 years ago, when
Can we talk about a topic that I think is underappreciated? We just alluded to it, this Wilson versus Shaw decision.
Yeah, let's talk about that one, because that is much less well known than some of these other cases, but a really interesting one.
I wonder, when I look at sort of the built environment, just as I don't consider myself a utilitarian or like ends justify the means. We should pay attention to the outcomes. I think it's worth paying attention to the outcomes, but I kind of consider a lot of these things from a moral perspective of what's right or wrong. And when I step back as someone who's interested in human settlements and the form of them and how they look and how they shape our communities, I might say that Wilson versus Shaw has had a bigger impact on human settlement pattern and sort of the post-war divergence and sort of how we started building places than has zoning. And the federal investment in and maybe it was the timing of it, and the kind of the federal government was sort of unleashed to begin building infrastructure not long after Wilson versus Shaw, at a time when enthusiasm for the automobile was sort of exploding.
Yeah. And
so they just were like, we're going to start, it's going to be cars everywhere all the time. And that continues to this day. I mean, the infrastructure project that's going on I-285 around Atlanta, the federal infrastructure project, I think it's the most expensive in the galaxy in the history of projects. It is insane how much money is being spent on this stuff. And so when I think about like everybody, at least now, and I'm glad they are talking about zoning, but like, hey, how shouldn't we be talking about the federal government's, policies here with regard to, making internal improvements, things that our founders largely considered crazy and we should never let happen.
Right. Well, interesting thing too is this case, right, is decided in 1907, which is just about the high water mark for the railroads. And roads themselves, I mean, the car at that point is 1907. That would still be a luxury item.
It's a novelty. People were not really.
Yeah, it's a curiosity.
Yeah.
It's not been mass marketed yet. Henry Ford hasn't come up with the Model T. Most of the country's roads are really in kind of decrepit condition at this point because the railroads are the way to get around. There's no highway system. So the idea of the federal government, even though it's alluded to in the opinion, building a network of interstate highways that not only connect cities, but actually bisect cities and carve up their downtowns, run through neighborhoods, doesn't seem to be foreseen by the court. But nonetheless, they set that precedent in a way, using the example of the railroads, like, some of the larger railroads, the Intercontinental Railroad, to set that precedent. But they essentially say, it's like you said, it's too late in the game now to question these. It might not be explicitly mentioned in the delegation of powers in the Constitution, but it's been done before, and this is, times are changing. So it's interesting. They really do give a blank check to the federal government to not only fund these sorts of projects, but actually plan them out as they would do, starting about 15 years later, and then particularly starting in the later 1940s, right, where highway funding gets or highway construction gets funded to 90% by the federal government, whereas the railroads, not until the creation of Amtrak years later, don't really have that same kind of investment. And municipal mass transit is, again, also largely left to local finance.
Well, and kind of we think about Amtrak now and it growing out of the lack of commercial viability of passenger rail in the private sector, which there's a lot of reasons for it, and this would be simplifying that. But essentially we socialized the cost of the infrastructure that would provide a transportation means that would directly compete against passenger rail. And I'm not going to forgive sort of the corporatist stuff that was going on in railroads. There was some crazy stuff going on there as well. But passenger rail kind of became unprofitable because the federal government subsidized automobile infrastructure and auto transport. Is that would you agree with that?
I think so. If you try to imagine, how American transportation would look, whether intracity or intercity, in the absence of this overwhelming federal funding for the interstate highway system, surely it would be, you probably see a smaller network, more toll roads, where drivers are actually paying the cost of using the roads directly rather than it being taken out of the gas tax and general revenues. So some of the interventions actually that people are talking about now, some of the congestion charges or user fees, and a less extensive system. The other thing is, yes, other countries have built intercity highways as well, but the decision by the federal government to use those funds to actually build the highways directly through cities and to condemn parts of neighborhoods, in that sense, to make them a direct competitor with commuter subways or rails in a way that typically in other countries they were not, right? They would be belt roads that were designed to connect cities and then feed into them. They were not designed to be a way to get commuters in and out of the central business district. That was the role for existing rail systems. So those sorts of those decisions, which, if a municipality had to fund that, that'd be a lot more expensive to do that, to condemn that much land. And the municipality probably wouldn't have, there would have been financial considerations there about removing that amount of land, valuable land, from the tax rolls. So I would agree. If that hadn't happened, you'd probably have seen a much more balanced transportation system rather than, of course, it didn't have to be that way. Could the federal government also have put a tremendous amount of resources into building up local mass transit, investing in high-speed rail, things like that were actually just policy choices? They're not necessarily the result here, right? They could have used these powers in a different way. But yes, I think it enabled that exercise.
A friend I'd say I call him a friend on Twitter, someone I disagree with pretty much all the time. He was gently mocking my assertion that our rural areas would resemble very much the rural areas of northern England or Scotland now, had the U.S. not had our rural areas not had that sort of intervention, and talking about that as sort of naive. But I don't think it's naive. I think we would if you want to know what they took from us, go to northern England, and if you want to see what is happening now in the suburbs of Europe, is you see their version of sort of federal funding, their EU funding of big infrastructure projects that are, building an interstate highway system that's going right into, it's kind of they may be happening 50 years after we did them, but they're happening now. Hopefully they will learn more quickly and stop doing that.
All over the place, from Eastern Europe to superhighways being built in Poland and Slovakia, all the way over
India,
India and other countries as well. We see them popping up at a certain level of economic development, which I don't want to suggest, it's an inevitable process that, everybody, once they reach a certain level of car ownership, will get there, because that's not true. You see, there are plenty of cities in the developed world where, transit usage is extremely high, and there wasn't comparable investment. Instead, the government made investment in high-speed rail. I guess Japan's the obvious example, right? Mm-hmm. Where you have, yes, there are highways, but there's also enormous investment in rail and much more liberalized land use. But England, I was going to say, they, of course, in the late 1940s, just as car ownership was really going to rebound, they passed the Town and Country Planning Act, which is controversial now as a restraint on development, but was intended to preserve the English countryside from being gobbled up by suburban development. It was, I guess, fairly draconian as far as new construction was concerned, and has had ill effects, but I think overall it's done a pretty good job about at least concentrating development, making sure development is dense and not a leapfrog, sort of a shotgun approach to development where you have clusters of houses popping up all over the landscape. Could that have been done in the United States? I mean, there was one city which tried something similar to that, which is Lexington, Kentucky, in the 1950s. They passed their own local version of the Town and Country Planning Act to preserve the horse farms, which they saw in imminent peril of being overrun by large lot houses, and decreed a 40-acre minimum lot size outside the urban service boundary, and that everything else had to be built within the boundary. And they have that to this day. It was never challenged in court. If you zoom in and look at it, you look at the city, you see a very tightly defined city boundary beyond which are these expansive open spaces, whether they be agricultural operations or just horse paddocks or whatever. So that did.
That sounds like. Is that similar to what Nantucket has?
Yeah, I think somewhat.
Yeah,
somewhat similar to that, although not quite as ambitious. But that's one place that pulled it off. And you see a similar pattern where agricultural land values are very, very high, like out in California, and it just doesn't make sense to sprawl. But
my initial reaction to that is that is kind of the other end of the horseshoe of the same type of thing. That it was a kind of maybe an interventionist. I was totally unfamiliar with that about the UK.
Yeah,
but I wonder if that's if the need for that was a reaction to that people would feel the need for that was a reaction to how the built environment was beginning to change as a result of other policies that were pushing that change.
I think so. Certainly a reaction to increasing car ownership. Remember, this is the late 1940s, and the wartime.
You had the highway acts of like 1919 or 1719 and like 29 and.
So it's sort of a far-sighted measure. Which today is criticized as also having a similar restrictive effect on housing production. But it doesn't have to be that way, because there's a difference between setting an urban services boundary and allowing extensions of that boundary to accommodate new housing, which is sort of the way Toronto grows, the way some other cities grow, and zoning, which simply freezes things in amber and doesn't really have any plan for expansion. It's just
like kind of the worst part about it with zoning is you're going to restrict what people do, but still indiscriminately expand infrastructure out. So you have the cost of all your infrastructure that you have to deal with that's indiscriminately expanded out into, for miles and miles and miles, but no tax base to support.
That. American zoning is pretty indifferent to infrastructure. It's responding to localized concerns and community complaints rather than generally a coherent plan for a town or for a city.
And do you have a take on, do you give it any thought, why people seem to pay so little attention to Wilson versus Shaw? And is that just sort of an obscure thing that is maybe I overemphasize in my own, but it's, I just never hear anybody. I ask people who are in our space, and they're like, I have no idea what you're talking about. I've never heard of that.
Yeah, no, Jeff, until you mentioned it to me, honestly, I just sort of dimly aware of it, and I have to look it up. And oh, this is the Panama Canal case, but it goes beyond that because they set this whole precedent about federal investment in highways, in transportation, in a way that sets the course for the next 100 years. So, it's interesting that it sort of passes under the radar in that respect. But yeah, it foreshadows everything that happened thereafter.
I'd love to get my brother Vince. I'll talk to him at some point, and it would be fun to have the three of us or maybe more people talk about this, because Vince he has gone way down the historical rabbit hole on this topic. And, reading all the sort of founders' debates about internal improvements and who was supportive of the federal government being able to get into that business back in the day, and who had commercial interests in canal businesses and who did not, and the kind of the Jeffersonians versus the Hamiltonians. And he is Vince, real estate developer, civic artist, historian of land use. He's a reservoir.
Interesting. Yeah, I'd be curious to hear his thoughts on that from that whole perspective. The court kind of glosses over it, saying, we built the Cumberland Road back in the 1820s. So, a national system of interstate highways. Yeah, that's fine under the Commerce Clause or whatever. Yeah. All right. Enough said. Affirmed. Yeah. So it's there's a lot more to it than that. So I'd be interested to hear what his thoughts are.
Can I ask you about, because I think you are pretty familiar with this, deed restrictions, and here I actually wrote something down to tee up this part of the conversation. Libertarian-ish. So libertarianish people often point to deed restrictions as a way for the private sector to address the problems that people who are more open to central planning say zoning addresses. They're typically referring to the types of covenants, conditions, and restrictions known as CC&Rs that come along with buying a home in nearly all modern subdivisions. My own view is that in the long term, those deed restrictions tend to be fundamentally anti-community, and that they generally foster antagonism, that they're a serious imposition on future generations who may not want to use land in the same way as the people of today want to use it. So in that way, I don't see most deed restrictions as all that different from zoning. Let me quote Jefferson here, and I'd love to get your thoughts on this. In a 1789 letter to his buddy Jimmy Madison, TJ writes, "No man can, by natural right, oblige the lands he occupied or the persons who succeed him. For if he could, he might during his own life eat up the usufruct of the lands for several generations to come, and then the lands would belong to the dead and not the living." I understand Jefferson may have softened his view on this later in life. My guess is you know better than me, but please tell me generally, like on the topic of deed restrictions, like, share with me your thoughts on this.
Yes, I think he said that in other words elsewhere. I know that was a topic close to TJ's heart. The land is for the living, in usufruct. So he had an antipathy towards existing owners being able to obligate following generations, to conform those generations to their will for the land, which is why I actually mentioned that the fee tail, which I think he
I want to hear about that
context, right? So this was the old, trust me, it relates to restrictive covenants. I'm not going off on a crazy tangent here. So going back to Europe, going back to England, medieval England, this is after the Norman invasion. You have this continental idea of entailed estates, to preserve large estates in a system where you have primogeniture, right? You're trying to avoid having the estate broken up. And you also want to keep it in the family. You put essentially a deed restriction on your estate. This person being a wealthy landed noble, probably a Norman noble who acquired major land holdings in England. And your heir, the eldest heir, gets title to the property and isn't allowed to sell it to anyone. So they get the land through inheritance, but it's entailed. It's entailed in their line of descent. So you tie it up so that they can't simply sell it and go elsewhere. In a system of primogeniture, maybe the younger sons go abroad. Maybe they go off to the colonies or wherever and go off to seek their fortune. But whoever receives that estate, it's designed to keep it in the family, number one, and to prevent it from being broken up. And this was carried over into Virginia in colonial times in the 1600s, some other colonies as well, and was even strengthened in the early 1700s. I think later in English history, there was a legal procedure by which you could actually defeat the entail. It was a little complicated, but Virginia cracked down even on that. So this was seen, I think, by Jefferson and Madison and some others as enshrining an aristocracy, a landed aristocracy, whereas Jefferson's vision was not for laborers working on huge tracts of land owned by an absentee landowner. He wanted to see a democratic system of small landowners, yeoman farmers, right?
Yes.
He wanted to see the land actually broken up. So one of his achievements as a Virginia legislator before the U.S. Constitution was outlawing entails entirely. And they were all converted to fee simple so that the owners of the estates could sell them, could break them up, and could not restrict them to their eldest son. So you'd just be stuck with the property whether you wanted it or not. I mean, maybe you wanted to sell the property and move out to Kentucky or move out to Ohio. Or
I imagine that politically would have been popular, right? Like I would think there would be support for that sort of thing.
Apparently, yeah, I don't know exactly how popular it was. But I think by that point, Jefferson and Madison were sort of winning this intellectual debate about what the country was supposed to look like. And, after the Revolutionary War, or, right around that time, there's an antipathy to these old European ideas of a hereditary landed aristocracy that could just, sit in their estates and live off the labor of others on their land.
So may I ask, what? And I was completely unaware until you emailed me about it earlier today. But it's called the entail, entail, right? Or a fee tail. Are those terms used interchangeably?
Yeah, I've seen them used interchangeably.
And so, when we're watching Downton Abbey. And this is a big deal because they don't have a male heir in the family or something, and they got to go to somebody's cousin's son or something, and he becomes the new the estate is going to pass to him at some point or something like that. I can't remember. The show starts off where the guy in line dies on the Titanic, so they got to go figure out who's going to. Well, what would happen if there wasn't anybody? What would happen to the land if there wasn't any progenitor?
It would revert to the grantor, was the person whom the land came, and if the king or? Well, it could be, or it could be the prior owner if they're not deceased, and if the prior owner is deceased, it would go to the heirs of the prior owner. So whoever gave it to you, maybe it would end up going to one of your brothers or somebody else within the family, but you'd sort of retrace your steps back and then find another inheritor who would pick up the entail. And that way the estate would stay, hopefully, it was believed, stay within the family and stay intact. So in most of the U.S., this wasn't a thing. It sounds like it was a thing in Virginia. It was present in several other states as well before the American Revolution. Sort of then, at which point these ideas fell into disrepute. And even in the territories, there were a lot of laws passed by the territorial governments preemptively outlawing this form. The idea was widely distributed land ownership rather than concentrated land ownership. That in a country this big, each person could be his own boss. Each person could be, her own head of her own farm, head of her own business. So there's enough land to go around. We're not trying to replicate a system where you have just a handful of landowners controlling anything. Anyways, I think this ties back to restrictive covenants because it's in a way it's similar, right? You're putting a restriction that's supposed to persist and bind others to your will, your vision for a neighborhood going forward. Maybe it's 10 years, maybe it's 20 years, maybe it's 30 years.
And there are some statutory limitations on how long they can go out or some conditions. There's a means to relieve yourself of that, of those deed restrictions, but it's not easy to do so. Is that right?
That's right. It was interesting. It was the same thing that happened with entails. Originally, it was only supposed to be for one generation, then for 2 generations, then for 3 generations. Then it got extended out to being indefinite. And you see some uncertainty with these restrictive covenants, which instead of binding just one landowner, purport to bind an entire neighborhood. Anybody who moves in is subjecting themselves to this.
And so, to interject, like libertarians are cool with that. They're like, because they're just everybody's opting in.
Everybody's opting in. It's free choice, right?
They don't have to do that. There's 2 things about that. One, if you want to comply with the Interstate Land Sales Act and you're developing a community over a certain size, the law obligates you to create covenants and restrictions. So many developers are obligated to who wouldn't otherwise do it. And then secondly, there's a lot of people who are going to be dead and then new people born who come in who are encumbered with that asset or their options to buy something. They don't have options to buy something that's unencumbered or their options are abridged. I view it as a lot like zoning. I view it as kind of a zoning thing.
It is, but I would say, while there's a lot of negative things you could say about it. And this is one thing that Nolan Gray addresses in Arbitrary Lines with respect to restrictive covenants versus zoning. It's also an excellent book. It's an older book, but it's still probably the best book on restrictive covenants, which is Land Use Without Zoning by Bernard Siegan. It's out of print, but very interesting.
No way, it's out of print? There wasn't big demand for that?
I know. I found some copy off Amazon. It's just sitting on my bookshelf. But he's a San Diego law school professor from a long career there. But one thing you can say is, typically, yes, they do have an expiration date. Usually, after a period of time, courts will cease enforcing them. You can put limitations on them. For example, you can say after 20 years or 25 years, you need a vote of X% of the landowners in order to renew it, right? You can make them renewable, and you're probably not going to get that support. And unlike zoning, they're not universal. In Houston, without zoning, yes, you have a lot of restricted properties. Yes, that's annoying. Yes, you have to opt into it and you have no bargaining power. But at least it doesn't cover the entire city. And those people who, when building a neighborhood, want to have some restrictions can get that without imposing it on everybody else. So not to say that it's necessarily great, but in some way it's at least better than some of the other alternatives. You read the early history of zoning, and I tweeted out about it, but Bassett is talking about how zoning is superior to restrictive covenants because it's universal and it's of unlimited duration, whereas restrictive covenants tend to, after the passage of time, get forgotten and it's hard to enforce them. So
I suppose they're puts and takes. My view is they shouldn't be. I bristle a bit when I hear the property rights advocates in general sort of take up the torch in favor of them, and while they may not be as broad reaching, they also get way up into your britches, like controlling all sorts of things that are totally bizarre. Essentially, whatever the creators of them decided to restrict, provided it didn't violate the law. They could
right.
have them restricted.
Typically these are set up by a single developer. I mean, there's the other upside is that it'd be almost impossible to get consensus for a new restrictive covenant in an existing neighborhood. I mean, politically, all you have to do is persuade a few legislators. Mm-hmm. But when it comes to restrictive covenants, you need direct opt-in from the property owners. So once it expires, it's going to be very hard to get it back. Whereas zoning was imposed top-down in theory, it's perpetual. If nobody changes it, it's not subject to renewal. There's no sunsetting on zoning. So I think that's what I'd say. Look, I don't love it. I think it has a lot of the negative characteristics you saw that made Jefferson that sort of motivated Jefferson's attitudes about the fee tail, about trying to impose your will on future generations and use the courts to enforce that will on them. It has some of those aspects, but those can be mitigated to some extent. And if that's the price for liberalizing zoning, it might not be
the
worst deal.
And two, I can argue with myself on that issue some and be like, well, there are actually some really useful deed restrictions. Like, I need my neighbor and I may negotiate some joint use of something that my property depends on for survival in terms of some utility or some sort that requires a deed restriction that lasts beyond either of our lives. I guess I can make the arguments either way, but I'm still kind of like, I'm suspicious of those. I'm partners with my brother and father in a real estate development company, and we regularly reflect on our own CC&Rs, which we created out of some degree of obligation, but we had a great deal of internal debate among the partnership about whether or not we should have them, what they should look like. And for a number of reasons, this was, in the late 90s or the mid 90s, so it was a long time ago. We were early in our philosophical exploration about these issues, but could we do it all over again? We would I don't know. We would probably still do them, but we would do them very differently. It's developers, I think, when they're creating them, right. I don't feel like they bring sufficient seriousness to the task. They're essentially writing constitutions that are going to outlive them and outlive all their first buyers, and are going to affect children and grandchildren who move into the place. And I think they need to bring a little more philosophy and foresight to it, not outsource that to just someone who writes covenants and restrictions, which is how it tends to get done. I
think it's especially the time frame that's important. I mean, you can write something pretty restrictive, but as long as there's some end date on the scale of how a city develops, it might just be a small fraction of time.
That's true.
If it goes away, whether that's 20 years, 25 years, even 30 years, whatever is beyond the time horizon of the immediate buyers, looking ahead, I mean, most people that's not going to influence their decisions. I mean, you never know what's going to happen down the line, but that accounts for some of it, I think. And that can also be changed by state law if there's a concern about that.
It may just come to be a best practice by developers to be more thoughtful about how they write them and create near-term sunsets and lower the standard lower the amount of objection needed to sunset them, things like that.
I do that too.
Can it related to this in terms of it sounds to me like you're at least a little bit familiar with the notion of right to roam. Is that right?
I had been just a little bit. Then I read that very interesting article you sent to me talking about how it works in Scotland. And
Ken Ilgunas. I'll link to him. I've actually spoken with him before. He lives in Scotland now. He's an interesting guy.
Okay.
But so I began thinking about this issue. I probably read that article. This is Right to Roam. So the idea of right to roam, and it relates to kind of how we think about property as Americans, and when we have right to our property, what that means. In the olden days, really, I think maybe universally in the colonies and then later the United States, you as an individual, there was really not a prohibition against you walking across someone else's land. There were things you would avoid, but unless it was fenced off for some legitimate purpose, you could walk across someone's land. And this was not this is essentially how it had always been in Scotland, and had been in England for a very, very long time. And there's some history there too. But it was that way here up until kind of it was generally viewed as such until maybe around 1900 or give or take 10 years in different areas. But it was such a cherished right that it was on the table as a consideration for inclusion in the Bill of Rights. And my son taught me this, and he was studying the Constitution, that the things that made the list of the Bill of Rights were things that everybody agreed, yes, definitely. This is something we're not going to argue about. It would be crazy for us to not be able to have free speech. Of course, everybody can have that. And it was widely held that, but then at least the little bit I've read, it was not included because the cultural differences for how right to roam were interpreted were so vast from region to region that people just couldn't really agree on it. But for the most part, everybody was like, yeah, you can walk across someone else's property. Is that, and I know you haven't studied this in a great deal, does that generally jive with your take on this?
I think so. I do. Just as you're saying this now, I wonder if any state has a right to roam provision in its state constitution. Not that I'm aware of offhand.
I think Pennsylvania does. I'm not certain, but I think it does. And the Pennsylvania delegates at the Constitutional Convention were the ones who were like, hey, we need to put this on here.
Okay,
it didn't pass muster. I've thought about it more recently. That article that Ken wrote, and I'll link to it. I encourage y'all to read it, especially if you're like into backpacking and things like that. I think it's especially hiking, whatever. I think it's fascinating. But our place in the mountains, and I think my next episode I'll be recording up from there, thankfully. But it's kind of a agriculture area, and there's a lot of old timers up there, old families, such as old timers and old families who've been there forever. And my neighbors, they talk about in the very not distant past, hunting the whole mountain that we're on. Like it was just understood that you could go hunt on any, we knew everybody, you could just go hunt on everybody's property. And as new people who have begun to move in and buy property, large tracts of land, often really wealthy people, their conception of that is not the same. Like, it's my property. You cannot walk across my property for any reason, much less carrying a gun. And that for people who've grown up in that area, that was just what you did. So this whole notion of what it meant to own property and the ability to exclude was very different to them culturally than what the law allowed. The law, of course, has allowed people to exclude, but it's created real resentment between people who've grown up in the area. Their families have grown up in the area. They grew up as little kids being taken by much older people hunting, on the mountain all over. And understandably, some, large, wealthy landowner who is maybe from London or New York and buys 300 acres on the mountain, and some guy's tracking his shot deer across the property with his gun. And so the property owner calls the, police on him. And that happens. And I kind of, in that situation, I'm like, well, they're both right. And what have we lost by excluding, by taking from people the right to roam? I think we've lost a lot. And it makes this whole issue makes me think of all these other things about the way we view property today, what we have a right to do versus what we don't. This is one of these things where I feel like I fall very much in sort of a very progressive, capital P, I guess, progressive view on what property should be. And like, if you're not taking anything from anybody, if you're not damaging it, if you're not invading their privacy, why can't you just walk across their property?
Right. And I think the concept, right, that yours is whatever you can enclose, you can physically enclose, you can fence off a paddock, or you can enclose a field where you're actually farming. You don't want somebody, trampling all over your, whatever it is you're growing. It's like, okay, I understand that. But beyond that, if something is not enclosed, but nonetheless is under your ownership, that should be open for people transiently passing through. I mean, maybe not camping there or setting up a homestead there, but you haven't enclosed it. You haven't essentially made it part of your property. You simply have the title to it, right? Mm-hmm. To make it your property, you have to, with the old traditional natural rights, John Locke view, you have to actually add some labor to it to make it yours. Stake out put on a fence post. And beyond that, it's in theory yours, but in practice, should be open to people. That shouldn't be considered trespassing. In New England, it's an interesting concept because, again, particularly with the decline of agriculture, you do have a lot of these open, ambiguous spaces where it's easy to hike through. They're really, in many cases, even where I live, there are no markers even for the property lines. Mm-hmm. Unless you're carrying a GPS or you're a surveyor, you can't even really tell whose property you're on. Nonetheless, I think there's still some attitude, well, I want to be careful, stand by side of the line or this side of the line, even though there really, practically speaking, aren't any consequences to it. So it's almost a mindset. Right. And you still see in hiking in the woods, sometimes you see a no trespassing sign, which implies that, well, you might have the right, but you might think you have the right, or there might be a cultural right to it, but I'm going to assert this right I have to exclude you, right? Otherwise it would go without saying. So I think there's room, particularly in some areas of the country, for revitalizing that idea.
I wonder how it would happen. Like, my view is, or my understanding is it's happened legislatively in Scotland, and I think they call it right to roam. They might call it freedom to roam. But property owners are insulated from liability and people who are roaming except open themselves up to liability. They have obligations to the property owner when they cross their land, and property owners are insulated from lawsuits.
Yes, that's true. Even from trespassers, in some cases, you can potentially be liable if you're aware that they're there. So it would have to be accompanied by some reform to liability laws.
Yeah, there's a bunch of my son and I have hiked a bunch of 14ers in Colorado and would like to hike a lot more. And generally the access to the tops of those mountains is owned by mining companies, and they just let people, most of them, they just let people hike on them. But there have been some injured hikers who prevailed in lawsuits against the mining companies over the last few years, to the extent that now several of those 14ers are going to get closed down because the miners are like, we don't want to be sued by people hiking on our land. It was we were all fine with it until you started suing us.
Right. Yeah.
There's a great hiking trail near us in the mountains that is all across private property to a beautiful waterfall. And there's a sign on it like, hey, you're on private property. Take care of yourself. We keep this trail open for you as long as everybody's nice and well behaved. And everybody's nice and well behaved. But the owners of it are pretty diligent about making sure that trail does not appear in trail guides or on all trails or things like that. But I wonder if there's an opportunity for legislation there somewhere that might better protect property owners and make them less concerned about the risks associated with that.
Yeah, it's interesting. For example, like local premises liability laws in most states don't even contain a category or a right to roam category. You have invitees, right? People you explicitly ask to come onto your property. You have licensees, those who have the right to enter your property, like
like a tenant
or a delivery guy,
yeah,
or the mailman or whoever it may be. And then you have trespassers, those people who are entering without your permission. But there's no category for, I guess it would be a licensee to some extent, analogous to a licensee, but there really isn't somebody just passing through, right? They're usually there to do some sort of business. They're licensed for some business on your property. Essentially a trespasser from whom you don't bear liability because they have some sort of limited right to pass through the land. So it would require a little bit of, I think, a modification of that rule or some clarification of it. Otherwise, you will probably see some lawsuits. It's difficult for a trespasser to recover, but they wouldn't be considered a trespasser. So you would have some sort of higher duty, which, like you said, the landowner is not going to be happy about that. Like if I'm aware that people are roaming across my property, then I undertake a duty of care to them to, protect them from certain hazards or whatnot. It's like no landowner is going to want to take that on. So you would have to.
And that's how it generally is here, right?
Yeah. Even more so if somebody has a legal right to be on the property. Right. Yeah. If the postal worker comes onto the property and gets bitten by a dog, or one of the front steps is rotten and he falls down and gets hurt, there's potential liability there, even if you didn't make a specific request. So the framework of premises liability law doesn't, in most states anyways, I'm aware of, doesn't take into account that category. So that would have to be.
It would seem to me to be, I think about a lot of things in terms of pro-community and anti-community, what brings people closer together or atomizes communities. And the whole right to roam thing seems like the most pro-community thing out there. Like interlopers may not, they have to act respectfully on someone else's property. And within certain, in certain circumstances or most circumstances, unless they're messing with your stuff or invading your privacy or damaging your crops or scaring your animals or whatever, it's totally fine. They can come on. They're not taking anything from you. And it would seem like a way to bring people closer together. And I too wonder, with all of the land that we own, states, counties, federal government owns, so that people can use the land, like public use of it. I wonder how much of that land could pass to private ownership, and no longer be a financial burden to governments if the landholders could own it with a right to roam provision attached to it. Like, what would that mean for like the national parks if they were a bunch of like privately owned, but people could still kind of keep going and using them?
Right. It would be a whole different attitude towards them. Yeah. I think usually this is in the context of much larger pieces of land. Like, what would a right to roam be in a neighborhood of houses on a half acre, with fences?
Yeah, that would be different.
It's more like a natural environment where you're talking about much larger parcels. But that could still be done, for example, here in Newtown and other New England towns, because you have so much land which, although technically in private hands, isn't even really buildable, right? It's a wetland, or it's a stream, or it's rocky, or it's steep, or whatever it is. And right now there's no mechanism for that. The only way the only avenue we have is for a local land trust to buy it up, which takes it off the town tax rolls, puts an easement on it, and then it becomes open for they call passive recreation, which really just means walking through it. Now, could you do that with a house on the property if it's like a 5 or 10? I mean, sure you could. I mean, we don't have a way to categorize that excess land unless you use an easement or something like that for a trail, which, can be done, but no generalized idea that, that the unbuilt portion of your land should be that which is not built on or enclosed can be walked on. So you end up having to actually buy this local organization buys the land, which limits how much it can actually do. You end up with a little parcel here, a little parcel there. And if you're actually going for a hike, that's not going to help you very much if you have a bunch of separated parcels. So
you also have large organizations that are doing that as well, like the Nature Conservancy buying up tons of land, and they generally restrict access to their land for the liability reasons we've described. But boy, what if the Nature Conservancy could open up all the land they own without concern for risk to the organization? That could be amazing.
I would just say, at least if you have a low density development pattern, the very least you can have is at least allow people to have walking trails and paths to get around that aren't strictly defined by property lines, and requiring that the only way you can get around is on these paved automobile roads where
I think it's a fascinating topic, right? Like the whole and what it means for how we think about land and what it means to own the property. And what rights you do have as an owner. And presently, I feel like one of the rights we have is the ability to exclude indiscriminately, even when someone else's use of that property doesn't remotely affect how you might use it, or that you wouldn't never even know that they'd used it. It just seems a little strange to me. I wonder how the world might be if that were different. I suppose it could be different. It became different in the UK.
That was so that is the Lockean concept of natural rights, right? The labor of his body and the work of his hands, we may say, are properly his, whatsoever he removes out of the state that nature hath provided, mixed with his labor. That's what Locke defines as property. You can certainly have title to land, but left in its natural state, no property is being taken from you. I'd
recommend that. Go ahead. Sorry.
So it's broadly, it's not inconsistent with that idea of natural property rights are, and that probably was why it nearly got into the Constitution. It's consistent with those same ideas.
Charlie, I loved speaking with you. I'd like to speak with you again. I think I'll probably get you to come back and maybe try to have a powwow with Vince as well. We can go deeper into some of these other topics.
I'm very curious to hear what his thoughts are on this. That's a fascinating topic and an underappreciated case. And thank you for flagging that for me. It was an interesting read.
Yeah, absolutely. Thank you for coming on, Charlie. Where can all of our readers find more about your work?
You can go to the Mercatus Center website. All of the things that I've written there are on my own profile page. If you just do search for Mercatus, Charles Gardner.
I will link to that
but I would also recommend the work of if you're interested in urban issues, anybody on the Urbanity team. That includes Emily Hamilton and Salim Firth, who are two other economists and researchers who've been doing this sort of work for going back several years, have really interesting work on zoning reform, housing production issues, tons of stuff to dig into.
Yeah, I highly recommend both of those people. I'll link to them as well. I think Emily has at least gotten a couple mentions on this show before. I think the work that I think people in the industry who are seeing how much great the emergence of greater awareness and the beginnings of really good things in terms of how the law governs how our land may be used. I think people who are really in the industry appreciate how much you guys at Mercatus are doing and how much your team is doing to influence that direction. I think you guys deserve much wider recognition for the great work you're doing.
I appreciate that. And, it's encouraging to see it get picked up here and there, by state legislators, even in the, recent White House brief. It's the word is getting around. So we're trying to add to that conversation. I was going to say, in addition to, we were discussing just very quickly, we were discussing the Braver and Somin paper, but I have, it's at least published on draft form, but I have a law review article that's going to be published, I think in May in the San Diego Law Review.
Oh, great. Is the draft available? Can people read the draft?
There's a sort of early draft version on the website, earlier draft version, sort of abridged version, but the full version will be published in May. It's sort of complementary to Ilya's article, Ilya and Josh's article. Sort of looks at the reinvigorating the rational basis test as to zoning rather than approaching it from a takings perspective with respect to minimum lot sizes, which so
explain to people why these articles are really important and how they help advance legal action that could go to.
Yeah, I think any new theory or suggestions about a new theory can form the grounds for a legal challenge, and some of these challenges have actually worked in the past. Zoning has not been a totally moribund field from the judicial perspective over the last 50 years. Something I write about in this paper is that there actually have been a lot of victories along the way, particularly in Pennsylvania, as it happens, a very pro-property rights state, while simultaneously, I think you said, being a right to roam state, which is interesting. So picking up some of these victories in the past, reassessing zoning and using them to come up with new strategies on the basis of property rights. And the paper's on minimum lot sizes, really, because I think that's one of the least defensible and the most irritating. I mean, particularly if you're talking about Jefferson's ideal of widely distributed land ownership in an urbanized society. What does that really mean? And if you can't divide up land to sell it off, you are impeding that, right?
You're essentially creating an incentive for a landlord class who's, it's a benefit to multifamily developers, large scale multifamily developers.
Right. I mean, and you do have condominiums and HOAs that can get around that to some extent, but excluding that really stands in the way of that idea of widely distributed home ownership in land ownership in an urban context. It's part of the reason I focused on it, because it is.
Oh, that's great.
I'd like to think if Thomas Jefferson were around, he would look at these minimum lot size. I can't believe you guys went there again. I mean, I dedicated my career as a legislator to making sure you could subdivide these big landed estates, and you've gone back and done the same thing in these suburbs, and the courts have upheld it. So,
a friend of mine demoed ChatGPT, like the latest iteration today, where it has voice interaction, and it's pretty cool. I think it's cool. I think I'm not concerned about it. It should be a different topic, but I wonder if I could have. With that, I could have Thomas Jefferson on the show and talk to him. Like, if we can say, ChatGPT, go read everything there is that Thomas Jefferson has ever written, come back, and I would like to have Thomas Jefferson on the show.
It's going to get there soon enough, right?
Yeah. I'll ask you to co-host that with me.
Animated Jefferson who can just, quote right from this enormous volume of letters from we have. Yeah, we could probably do it.
So your article, Ilya's, others, my read on what happens is the potential plaintiffs or organizations like Institute for Justice or Pacific Legal Foundation, that's the right term, right? They use those as the basis for helping plaintiffs bring suits that will end up going through the courts and eventually clarifying the law or changing the law in ways that better protect, better represent the interests of property owners, or maybe even something as ambitious as reversing Euclid, which would be an aspiration of mine. And also on the legislative side, the lawmakers take note of them, and they're like,
yes.
It makes sense that we should not have land use policy that's regressive in this way or counterproductive, and they change the way they invest in infrastructure or they write land use rules.
That's an encouraging thing, because there are a variety of ways to get to the same destination. And if it doesn't work on one end, it might inspire someone else to change their policy. And in Texas, the state legislation didn't succeed on a couple fronts, but that lit a fire under a couple of the cities to start doing it. And then, you have your court challenges as another way of putting pressure on the issue, or at least calling attention to it. So these are all the avenues that are open to us. But that's generally, I would say that's the intent of the paper, and also just to spark a bit of a discussion about it more generally from other people to weigh in and say, add their own thoughts.
Well, it's I know it's hard to see the big victories don't come often, but I have had the great benefit of being able to look at the progress over the last 3 decades, and we are seeing the progress thanks to the good work of people like yourself. You can find Charlie's work under Charles Gardner, Gardner, on the Mercatus website. And you also, is your Twitter handle?
At Old Urbanist, which was
Old Urbanist, right?
The name of the blog, which is still up. Blog is still up. I haven't written for it in a long time, but
you're not very old, though.
Somebody just mentioned
when it was actually Emily Hamilton who was like, "Oh, you need to connect with Charlie and his, it's Old Urbanist." I'm like, "Oh, he must be like a wizard Gandalf or something." But no, you're not.
No, I need to add a filter. No, it's funny because I remember 10 years ago, because I'm glad you're still saying that. Somebody mentioned that to me. It was more than 10 years ago. It's now, but it's like, you're not very old. I said, well, just wait. I'll get there, hopefully, That
was aspirational.
Yeah. So 10 years later, I'm glad I'm still not quite in that category yet. But no, it had nothing to do with chronological age. It was just riffing off the new urbanism and my critique. At that time, and sort of tongue in cheek, that this was based more on much older city building patterns. Yeah, no, I like that. I have a lot of that. That would be another topic. I wish I'd brought it up earlier. That would be another topic to go down. That's a whole other hour. But next time we will do that. Charlie Gardner, kind of professionally, you'll find him as Charles Gardner. It has been a delight to have you on the Yeoman podcast. Thank you so much for joining me. Jeff, thank you very much. Appreciate it. And great talking with you. Likewise. Okay.